Are you ready to take a bite out of the competition? Are you looking for ideas to make your business better? Welcome to the Core Business Show with Tim Jacquet, sponsored by Apple Capital Group. At the core of every successful business, you'll find people making a difference. And with each episode of the Core Business Show, we talk with those people, examine those ideas, and explore the strategies that make them special. Now, the host of the Core Business Show, Tim Jacquet.
Welcome to another episode of the Core Business Show. I'm Tim Jacquet, your host. Today we're going to talk about bankruptcy concepts to juries. If you'd like to join the conversation, please give us a call at 347-324-3460, or you can pose a question in the chat room or email us at info@thecorebusinessshow. We're going to take a break for a moment and we'll be back with our host. You listen to the Core Business Show.
You're listening to the Core Business Show, sponsored by Apple Capital Group. Apple Capital Group in Jacksonville, Florida, is a commercial lender that specializes in asset-based loans, equipment leasing and financing, invoice financing, commercial real estate loans, and asset-based financing in the U.S. and Canada. Apple Capital Group is a direct lender that lends on their private equity investment portfolio. 90% of most loans are decided within 2 hours, and vendor funding within 24 hours after documents are completed, with a one-page application. No slow no's. Just a quick decision and a fast yes. To get more information about lending from Apple Capital Group, call 866-611-7457. That's 866-611-7457 to speak with one of our loan specialists. Or visit us right now at applecapitalgroup.com. Welcome back to the Core. Once again, here's Tim Jacquet.
Welcome back to the show. Presenting bankruptcy concept to juries. Sarah, thank you for coming back on the show again.
Hey, thank you for having me twice.
I guess for the very beginning, because this is a different episode, you might kind of tell us again about yourself and how you became attorney and writing this article.
Sure. I'm a trial lawyer that practices at the firm of Squire Patton Boggs, formerly known as Squire Sanders in Cleveland, Ohio, partner in the litigation group, and try a lot of business cases. So one of those areas includes trying business cases within the context of a bankruptcy in which one of the parties has probably declared bankruptcy. And so you're there because probably your client is not getting paid fully on its claim, and maybe it's because of something having to do with the bankruptcy rules, and maybe it has something to do with the claims of the other creditors, or maybe it just has to do with the validity of the client's claim all by itself. But that's why you find yourself there. And when you are in that place, you have to find a way of conveying to the jury, people that don't deal in bankruptcy concepts in their day-to-day going about their lives, you have to explain to them why it is that you should get what you want, and why the fact that your client's claims, at least according to you, satisfy the requirements of the bankruptcy code, but also why doing what your client needs them to do is the fair and right thing to do. So that's a bit of a challenge.
Kind of take us back for a second, because there's 2 bankruptcies, 13 if they're personal, and 11, I think, if there's a business. And most cases, you just have a judge. Kind of walk us through and make sure we have this clear picture that you would actually have a jury. Will you have a jury on both ends if you're filing personally or you're filing for your business, or everything is by the judge?
Yeah, you're absolutely right, Tim. Ordinarily, you're in front of a judge, and not just any judge, but a specialized bankruptcy judge who understands the ins and outs of the bankruptcy code, and you don't have to spend a whole lot of time in those situations discussing why a certain result is fair or unfair. However, if you have a complex issue or a distinct one, or if you satisfy any number of criteria that may pull you out of that ordinary bankruptcy court under the bankruptcy code, then you can find yourself in front of a jury. Sometimes it's an advisory jury, which is something that's happened to us, where a jury is impaneled, but they're really there to advise the judge. Their decision is not per se binding. But, at the end of the day, it will be. So for those reasons, you can occasionally, in bankruptcy proceedings, find yourself in front of a jury and not a judge. Happens more often with large institutional bankruptcies, not so much personal bankruptcies.
Okay. So, for example, if you're personal bankruptcy, and we can go to commercial in a few seconds, personally, it's really going to be between you and the judge. What cases that you have in this particular process, maybe you're a small business owner, you file 13 on yourself, what type of issues that will put you in front of a jury?
You can be in front of the jury if an issue is distinct enough so that the federal court will do what they call withdraw the reference. And if they withdraw the reference, they decide that there are overarching considerations in the dispute that is between the creditor and the debtor that don't necessarily require specialized determination by a bankruptcy court who has bankruptcy knowledge, but rather that can be determined by a general judge who then decides what to do with it. So say you've got a very big supplier dispute as between a bankrupt buyer and a viable supplier. And really what happens is that the dispute is it's not any different than any other buyer or supplier dispute that could be filed in civil litigation in a situation where no party is bankrupt. Mm-hmm. In that case, sometimes the federal court or sometimes one of the parties will petition to withdraw the reference from the bankruptcy court, and then you find yourself in regular court land. And so that's how that can happen.
Okay, so even though one person filed bankruptcy, the jurisdiction is still in the bankruptcy judge, but the judge can sign off for them to handle this particular dispute in a civil suit.
Right. It happens when resolution of the dispute doesn't necessarily implicate bankruptcy concepts. It has to do with the types of questions that are ordinarily determined in civil litigation, like a contested claim. If a supplier or if a creditor is lining up just to get his undisputed claims paid, that's something that's resolved by bankruptcy. If there are questions about whether there is a viable claim, and those are questions that would ordinarily be determined by state or federal or contract law, those can sometimes be, the reference can be withdrawn, and then you find yourself in regular court land.
Okay, and usually, I would say in one case, usually going to be a real large dispute that's dealing with a significant amount of money, because usually, I guess creditors are not going to take the chance of you beating up on this little bitty, creditor, not creditor, but I don't know if you call it defendant or a petitioner, going to beat up on the petitioner, and the judge usually is going to be more sympathetic on the person than actually going to be sympathetic to the company. So it has to be a huge dispute for him he or her to take out of his court and allow it to run its course. But usually, if that's the particular case, the bankruptcy judge has the last word.
With the references withdrawn, then the regular federal courts have jurisdiction. But the situations where this happens is not necessarily a small debtor or even a small creditor. I mean, just recall, this is America. Banks file for bankruptcy or the bank equivalent of bankruptcy. Major ones do. Car companies do. Airlines do. I mean, this is the world that we live in, especially over the last 10 years. And in those cases, there's a civil dispute between a bankrupt entity that's typically filing for Chapter 11, so it's going to be reorganized. It's not going out of business. In order for commerce in America to continue on, somebody has to adjudicate disputes that are going to arise between those continuing entities and whoever it is that they do business with. So in those situations, you're going to quite commonly see people withdraw the reference and adjudicate the regular civil dispute type disputes in regular court. And again, that's where you can find your juries. So in those situations, trial lawyers have to find a way of explaining the bankruptcy concepts and the bankruptcy rules to the extent that they're implicated, like which creditors get priority and why, in terms of concepts that juries can understand. And so you have to go back to the drawing board and you have to think about how it is that you explain these things, why some creditors come first. Or if you're in a situation where you feel like a creditor is coming first unfairly or trying to assert its rights first unfairly, you have to think of an analogy that people will understand. So let's say there's a creditor trying to assert primary rights in a bankruptcy. You explain to the jury that this is basically like somebody cutting the line at the amusement park and making everybody, who got there first wait till after they're done. That's not fair.
If it's a big enough bankruptcy, you have your creditors meeting, and sometimes not the creditors meeting, but the panel that your creditors are sitting on to make sure that the interest, I don't know what you call it, but I know you can have the committee, and that's a different dynamic. So is the committee dismissed and they allow this to move forward, or those creditors just sit in the background while this process goes on?
Well, there's certainly a lot of creditor interest in a situation where you have an individual civil dispute being fought out between another creditor and a bankrupt entity, whether it's filed for Chapter 11, usually the case, or otherwise. You will find a lot of people will be like, why is the courtroom so full? Who are all these people? It's the other creditors trying to figure out what happens because, of course, if the creditor that's involved in the litigation prevails, there's less money in the pot for everybody else. So everybody's kind of interested.
Can you give us an example that you can pull from that this usually will happen? Did this happen to one of the car dealers, car manufacturers, that they had actually a separate issue?
Here's an example I can use. A few years back when, the banks were not doing well in this country, we had a case in which we represented a bank holding company that was filing for the bank equivalent of bankruptcy. It was stopping operations effectively and selling its bank to somebody else. In the course of doing that, the federal government, the FDIC, which regulates banks, came along and said that they believed that the bank, and we represented the bank holding company, that they believed that the bank had broken some covenants with the FDIC such that the FDIC should have been allowed to step in front of all of the other creditors of the bank and collect something on the order of, I think it was about $500 million. Now, in that case, the other creditors were deeply interested in what happened with the government's claim, because if that government's claims were satisfied, that would leave absolutely no money for everybody. And what we were able to successfully argue and prove in front of a jury was that, and it was essentially the nature of a breach of contract suit between the federal government and the bank holding company, but we proved that the bank holding company never made the covenants that the federal government described, and so that left a lot more money in the pot for other creditors.
Oh, wow. And you talking about this particular article that kind of inspired you to write this, can I tell us this article itself? How did you come about in writing it, and what do you think the readers will get out of it?
That's an article that I wrote a few years back, and I think it's really not any different than any other trial lawyer instruction on how to present any kind of complicated subject to a jury. In each case, whether it's, why the federal government shouldn't be allowed to cut the line in front of other creditors, or in a supply chain dispute, which is what I principally do, why the widgets don't work and whose fault it is, you have to find a way of explaining engineering or bankruptcy or other technical concepts that most people don't deal with in their day-to-day lives. You have to find a way to analogize it to an everyday experience. So that's what I would inspire me to write that article. And as most trial lawyers who deal with complex subject matters, be it antitrust or bankruptcy or supply chain engineering issues, they all face the same difficulties. And this is something that corporate America, which is being represented at trial sometimes for these complex issues, helps with, because of course these people have ways of explaining what they do when they go home and talk to their kids, and so you just have to listen and figure out how it is that you communicate the realities of the situation, the realities of a complex body of information to people who don't deal with it every day.
Okay. So now you're taking that case, the jury made a decision. Do they make a decision as binding? You mentioned something at the very beginning, and does it go to the judge, and the judge makes the final decision?
In the situation of an advisory jury, technically, the jury's decision is not binding, but I've never heard of a situation in which a judge doesn't take it. Generally you don't impanel an advisory jury for your health, and so usually it's the case that the judge takes the jury's recommendation and then settles on findings of fact and conclusions of law that the judge then writes to match up with the advisory jury's decision.
Okay. And from there, does it go back to the bankruptcy court once it's resolved?
As a matter of fact, it does, it goes back to the bankruptcy court to be included as some of the terms of administering the bankrupt estate, but it's not necessarily approved by the bankruptcy court. It can be appealed, to be sure, but at that point, the bankruptcy court is subordinate to the ordinary federal civil court. Okay.
In the case of fraud and abuse by managers or owners, how does that third will or fifth will actually play in this scenario?
So in that case, what often happens is that you'll find the bankrupt estate, which is the company itself. It represents the interests of the company as opposed to anybody working for the company. The bankrupt estate will then claim against any bad actors to recover damages from any fraudulent conduct that occurred. And that's one of the many very complicated things that can occur in a bankrupt estate, is that there can be claims by the estate against people who've harmed it.
Mm-hmm. Okay,
and that is the kind of thing for which the reference can be withdrawn. Sometimes it is, sometimes it is not.
Now, sometimes it's dealing with criminal litigation. They can kind of prolong this for some time. Does everything just go on hold while that gets resolved?
Sometimes a bankruptcy, a proceeding of that nature will be stayed if there is a federal prosecution ongoing. Obviously, the results of the federal prosecution impact the viability of civil claims. If somebody manages to prove in a federal prosecution, criminal prosecution, that a wrongdoer is guilty by the standard of proof required in criminal cases, that's going to be very persuasive in parallel civil litigation. But usually, often the government does get to go first with that.
Okay, great. Anything else you'd like to actually leave us with?
No, maybe just the thought that presenting technical information to juries is something that, whether it be bankruptcy related, engineering related, antitrust related, international processes related. It's something that's becoming increasingly common in civil litigation, and it's important to figure out a way to present those concepts when they arise in a way that makes sense to people who don't encounter them on a day-to-day basis. And that is one of the interesting and fun and unique challenges of the life of a trial lawyer.
Wow. And if they want to get a copy of this article or reach out to you, how do they do so?
I would say that article is best able to be found on my LinkedIn page.
Okay.
My name is Sarah Rathke, and my firm is Squire Patton Boggs.
Perfect. Well, thank you for coming on the show again. I really, really appreciate it.
Okay, thank you, Tim.
Okay, take care.
Okay, you too.
Bye now. You listen to the Core Business Show, everybody. Thank you for listening.
Thank you for listening to the Core Business Show with Tim Jacquet. For a free quote on equipment leasing and financing, visit our website, applecapitalgroup.com. That's applecapitalgroup.com. And fill out the information to receive your free quote. We hope you'll join us for our next episode. And remember, you can always get to the core via iTunes. You'll find all our previous episodes there. Thanks again for listening to the Core Business Show with Tim Jacquet.